Assalamualaikum warahmatullahi wabarakatuh. My name is Hasnol KHATIMAH binti ABDULLAH, matric number 281996. We are from Group 10. We present some issue regarding the National Bank Act 2019. So, firstly, I'm sure many people know what Central Bank Malaysia is. Central Bank Malaysia is a statutory body that started operating. Central Bank Malaysia is a statutory body that operated on 26 January 1959 and is subject to the Central Bank Malaysia Act 2019. Central Bank Malaysia or BNM in Malay is the central bank in Malaysia. Its headquarters are located in Kuala Lumpur, and the National Bank of Malaysia is as the central bank to issue currency, as the banker and advisor to the government and to control the credit position of the nation. Now, let's see first what the role of Central Bank Malaysia. Firstly, play an important role in the development of the infrastructure of the financial system. Second, have a monetary policy stance and promote monetary and financial stability. And third, responsible for the stability of the financial system. And fourth is strengthen the financial market. It also include the foreign exchange market. Next is Central Bank Malaysia subject to the Central Bank Malaysia Act 2019. The Central Bank Malaysia Act 2019 and including also the Financial Service Act have a major impact on the Central Bank Malaysia to control not only financial institutions involved in the provision of finance and credits. The Central Bank of Malaysia Act 2019 has come into force on 25 November 2019. With the coming into force of this Act, the Central Bank of Malaysia Act 1950 Act is repealed and thus ceases to apply. Although the Central Bank of Malaysia Act 1950 Act is repealed, all existing appointment, transaction, arrangement and subsidiary legislation made or any act is done under the Central Bank of Malaysia Act 1950 Act shall be deemed to be made or done under the Central Bank of Malaysia Act 2019. In general, in relation to MUAMALAT matters, in May 1997 was the establishment of the Sharia Advisory Council of Bank Negara Malaysia as the highest Sharia authority. In this regard, the SAC of Bank Negara Malaysia has been entrusted and has the authority to determine Islamic law for Islamic banking transaction in business, takaful, Islamic financial business and Islamic development. The SAC is the main reference and as an advisor to Bank Negara Malaysia on Sharia matters. Therefore, the SAC should also play a responsible role for the certification of all takaful and Islamic banking products. Bank Negara Malaysia will also listen to the advice of the SAC in advance in respect of any Sharia issue, and they are related to business or in respect of Islamic financial transaction Bank Negara Malaysia Act 2019. Here we can see this matter has clarified that the SAC of Bank Negara Malaysia is as a reference to resolve any doubt that arises from a legal point of view in any proceeding related to Islamic finance and banking before any arbitrator or court. In 2019, in September, the Bank Negara Malaysia Act 1950 Act 519 was repealed because at that time, the Bank Negara Malaysia Act 2019 Act 701 was gazetted. The purpose of this amended Act is to further improve the function and role of the Bank Negara Malaysia SAC.
Warahmatullahi wabarakatuh. My name is FATIN NAZIFA binti Muhammad NAZRI, matric number 283105. Next is the relationship between Central Banks of Malaysia and Banking Islamic. The Law of Central Banks of Malaysia Act 2009 is an important amendment to the country. It dictates certain economical aspects to ensure that every transaction that occur in Malaysia would be a legal transaction. This means that the financial ecosystem within Malaysia would be regulated from the various state regime, social, economic norms and culture, financial reporting and so much more. The Act is one of the first in the world of legislation that is dealing with a central bank of a country, which includes a Sharia Advisory Council that regulates Islamic business and finance industry in an effort to achieve Sharia compliance and harmony with Sharia uniformity through the statutory body. The Central Banks of Malaysia Act 2009 prevails the rulings of Sharia Advisory Council. Not only that, the 2009 CBMA created a new provisions in this regard. Through the CBMA 2009 Act, they ensured that harmonizations of Sharia view within the Islamic financing business compared to the CBMA 1958 Act that regulates by Bank Negara Malaysia. This means that no third party or even outside Sharia body or committee will be given the ruling to the certain aspect in Islamic financial institutions. All of the Sharia ruling will be given by the Sharia Advisory Council, in which their ruling will be above any other Sharia committee and thus given the Council a more definite role within Islamic financial business. With the Sharia Advisory Council taking on a more definite roles in the Islamic finance, Islamic financial institutions can refer to or consult them for a ruling. In the 1958 CBMA, there are no equivalence provisions can be found compared to 2009 CBMA. So, in this case, the Sharia Advisory Council will play an important part thanks to CBMA 2009. So, any Islamic business can seek advice from the Council about their operations in order to ascertain that it does not comply or rally with any element inconsistent with the ruling of Sharia. Based on the CBMA 2009 as well, Bank Negara Malaysia has given the power to establish a Sharia Advisory Council in the matter that includes Islamic finance, which shall be the authority for the ascertainments as Islamic law of the sole reason Islamic financial business. In this way, the Sharia Advisory Council has given power to determine their every own procedure based on the section 51 subsection 2 of CBMA 2009. So, the Council can outline the rules and procedure for each and every section of Islamic financial system. The core functions of the Sharia Advisory Council has been listed in the CBMA and how they operate.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad AFIF bin Muhammad ABDULLAH. My matric number 282098. Okay, so background of the case involving Nasir Abdul Khalid Ibrahim versus Bank Islam Berhad. This case involved two parties, namely Bank Islam Malaysia Berhad as the defendant and also Nasir Abdul Khalid bin Ibrahim as the plaintiff. The defendant had initially provided two types of murabahah financing facilities to the plaintiff. This was to enable the plaintiff to acquire more shares in a company. The plaintiff has already committed an agreed violation. Initially, the plaintiff had default on the payment of the first installment. The plaintiff have issued a statement that the defendant have abused the BBA facility, which action contrary to the teaching of Islam. The plaintiff sought to declare the agreement invalid and thus void. Even the defendant have denied this claim, strictly relying on the principle of Sharia and civil law, which say this agreement is valid and binding between the two parties, namely the defendant and the plaintiff. The defendant had sued the plaintiff through a debt recovery action, stating that Nasir Abdul Khalid Ibrahim had breached the term of the agreement. At the management level, the plaintiffs have applied to refer several questions to to the Sharia Advisory Council of Bank Negara Malaysia SAC pursuant to Section 56 of the Bank Negara Malaysia Act 2009. So the issues in this case are Section 56 and Section 57 of the Central Bank of Malaysia Act 2009 contradictory and unconstitutional, whether the Central Bank of Malaysia Act 2009 Section 56 and Section 57 are discriminatory and violate Article 8 of the Federal Constitution, and the third one, whether the circumstances requiring the court to adopt the SAC on Sharia question relating to the Islamic financial issues are outside the court jurisdiction. And the last one, is it possible that the two sections have a retroactive effect?
For the judgment, the court has decided that they need to reexamine in relation to the issue that have been arisen between the plaintiff and the defendant. There is several issues they need to look into by SAC where every dispute in Sharia related. Among the issue that has been arise between the plaintiff and the defendant, where there is a breach of term in agreement under BBA between them with the concept of Sharia. Second is whether it is true or not the action of bank that is the defendant that has sold the plaintiff's share without permission after plaintiff have failed to pay the debt as has been agreed in the agreement. Third is whether the plaintiff agreement to settle his debt with the bank will be disposed of when there is Sharia breach in the BBA contract. Next, to resolve the issue between the plaintiff and the defendant where the plaintiff said and claimed that this case involving the Sharia issue should be overturned, but the court has refused and the trial is still open and can be tried. Therefore, the court is referred the issue related to the Sharia to the SAC where the SAC is governing body in field. Therefore, now every decision of SAC is no longer at the discretion of the court, but every case related to the Sharia issue will be given role to the SAC in making decision. In conclusion, SAC is a body that serves as the reference point on Islamic finance issue in Malaysia. This body also has responsibility of the safeguard every matter in Islamic principle under Islamic banking. So by following the act set out by the SAC, every decision made by the SAC must be complied with the preserved issue related to the Islamic banking. However, the court decision is still relevant as the SAC's decision will be used as the reference and expert evidence by the court.
Assalamualaikum warahmatullahi wabarakatuh, Doctor. My name is INTAN NURHIDAYAH binti Muhammad NASIR with matric number 265181. I will continue this presentation with you with my part, which is application related to the Act. What I'm trying to deliver in this part is about amendment that happened before and after. We will bring a few cases in this part to understand more about this Act. So we will look at the past cases related to the Sharia Advisory Council before the amendment, in which the role of the Sharia Advisory Council was set aside. Then we will look at example of cases that exist after amendment have been made to this Act. So before amendment, we look at AFIF Bank Sdn Bhd versus Zulkifli Abdullah. This case involved a claim defendant against IBRA, which is discount, proceed from BBA financing for buying a house, as well as some other demands. So in this case, Judge Dato' Abdul Wahab Pattaya had decided that the bank cannot reclaim the total amount of financing in the customer's case who failed to pay the monthly payment. That is a relevant decision in this case for the judge, because this judgment clearly indicates that there needs to be a paradigm shift in understanding and appreciating the principle and practices of Islamic banking is based on their own merits and not by comparison with usury-based lending practices. Which is mean in this case, we can compare between Islamic bank and conventional bank, because there are very huge or significant difference between those two. And in this case, you can see that it's clear here that the SAC does not have a strong power to bind the court and serve as expert evidence. That this is case that happened before the amendment of the Act happened. So we will look at the case that happened after amendment, which is Muhammad Alias. Through this case, the plaintiff raises 3 questions for court consideration about the SAC function. So in this case, Judge Dato' Zawawi Saleh is seen to have appreciated the new provision which recognise the existence and function of the SAC. He stressed that it was an obligation to follow the rulings given by the SAC, as the SAC was the highest authority to advise the court on issues that related to Islamic banking and finance. So in this case, we can say that finally they recognized and established the existence of SAC in Islamic finance and banking after the amendment of the Central Bank of Malaysia 2009. Okay, so conclusion for my part, the purpose of the amendment is to empower the SAC, and it is an opportunity to define and explain Islamic principle in the case which involve Islamic banking and finance. That's all from me. Thank you.
In conclusion, Bank Negara Malaysia is a body that safeguard and control the Malaysia economy, where everything related to the finance will be monitored by the BNM. Bank Negara Malaysia is governed by the Central Bank of Malaysia Act 2009. The role is to maintain the monetary and the finance stability in Malaysia. This act is also intended to maintain the existence of the Bank Negara Malaysia in terms of administration, function, objective, and the power of the bank. BNM also play an important role in the infrastructure of the financial system by building a secure financial system, such as the Security Commission, KLSE, which is now known as Bursa Malaysia, and the Credit Guarantee Corporation. In addition, for the Islamic financial system, which include Islamic law and principle, it is given the role of the Sharia Advisory Council of Bank Negara Malaysia (SAC). SAC is the body authorized as the reference and advisor in ensuring the Islamic finance in Malaysia is secure, where in terms of Islamic banking, Islamic finance, takaful business, and every institution that involve the Sharia principle. Here we have been revealed that there is a body under Bank Negara Malaysia that constantly monitor the Islamic financial system and every Islamic financial problem in Malaysia.